culture of human rights in the public sector. And the principle here is that if government wants to outsource its functions, that those obligations and that culture should flow with those functions at the same time. So I won't go into any detail about the rights protected, other than to note we have 23 in total, and that Queensland was the first jurisdiction in Australia, and at the moment still the only one to include a right to health services, access to health services. But we could do a whole presentation on what the content of those rights is, so I won't go through those today. So Chris is going to go through this with you, but just worth noting, if an entity is a core or functional public entity, which is what I'm going to speak to in a moment, these two obligations flow from that. That is the procedural obligation to give proper consideration to human rights when making decisions, and then this substantive obligation to act to make decisions compatibly. But Chris will go through that in some detail. So these are really the sections that tell us what is a public entity under the Human Rights Act. And a lot of what I'm going to speak to you today is drawn from these two sections of the Human Rights Act, Section 9 and Section 10. Just a note of sort of setting the tone, I suppose. In a Victorian decision, Justice Bell there said that it's fundamentally important to the achievement of the purposes of what is called the Charter there, and the Human Rights Act here, that we have a good understanding of what functional public entities are, and that it should be interpreted widely and generously with these purposes in mind. So it gives you a sense of how, if it comes to it, how courts are going to approach this question. So we have two different types, as I said, of public entities under the Human Rights Act. We have core public entities. They're entities that are having to comply with those obligations I mentioned at the start all the time. The Act tells us those are a government entity within the Public Service Act, a public service employee, the Queensland Police Service, local governments, ministers, what you might expect when you think of governments. I'm not going to speak much about that today beyond just noting those are the core entities. No matter what they do, they have those obligations. We also know what aren't public entities. The way public entities defined in the Act, we know Commonwealth government entities, Commonwealth government agencies aren't going to be called. This is Queensland law. Private schools are given as an example in the Act of not being a public entity. Private health providers, when they're doing private health services, might be a different story if they're doing public health services. We could spend a whole session talking about when Parliament, courts or tribunals might have public entity obligations. Let's not do that. And then the minister may, via regulation, prescribe an entity as not being a public entity, and we've had one of those so far, and that's for a grammar school, or grammar schools, clarifying that they are not public entities under the Act. So as I said, functional public entities is really what we're speaking about today, and they can come within three different areas within the Act. The one we're going to really focus on today is that first one, and you'll see it's a two-step test. Are the functions of a public nature? And if so, is the entity performing those functions for the state government or like state public entity? That's what we're going to focus on. Just worth noting, there are also functional public entities that they're established under an Act when they're performing those public functions. And finally, and this reflects that the Queensland Act really came along after the ACT and Victoria Acts, and learned from them, and developments that have happened since their passage, makes it very clear that if you're a registered NDIS service provider, when you're a provider performing those functions of public nature in Queensland, you are a public entity. There had been some lack of clarity around that issue, I suppose, and the Act really makes that clear. So as I said, there's this two-step test. Firstly, is the function public in nature? And the Act gives some criteria to think about, not exhaustive criteria to think about. Is the function given to the entity under an Act? Is it generally identified with the functions of government? And that's often going to be the key question, and I'll go through that in a little bit more detail in a moment. Is the entity regulating and in some ways a regulatory functional nature? Is it a government-owned corporation? And interestingly, also relevant to both this question and the second one I'm going to go through in a moment, is whether the entity is publicly funded to perform the function. Does the Queensland government or a local government council fund them to perform that function? Is relevant. So the Act also tells us some things that are definitely public in nature: emergency services, public health services, public disability services. As I said, we've got that very clear definition around NDIS registered providers. Public education, including public tertiary education and public vocational education. public transport, and then something that's really been a focus, particularly in Victoria, housing services funded under the Housing Act. So what is this? As I said, often the criteria that's going to be most relevant as functions generally identified with government. What does that mean? And this is drawn from some of the cases in Victoria. The sorts of things that are going to be relevant to that, and bear in mind a lot of those cases that involve social housing providers, is knowing that government has responsibility for the care and protection of vulnerable and disadvantaged people. So if the function's got that character to it, then already it's going to have that flavour of being a public function. The functions of government, though, can change as society changes, and often I think about, even though it's a Commonwealth function, something like telecommunications. That 30 or 40 years ago, we might have thought about telecommunications as something of a public nature. I think our view of what telecommunications is and how it's delivered has changed quite a bit. So that, what we conceptualise as a public function can change. The point is to pay attention to the function, not the entity that's performing them. If it's a really important function which the government exercises on behalf of the community and the public interest, again, that's going to show that it's something identified with government. And if the government's got a set of policies and programs which the function was carried out under, and that they're based in something in legislation. So some of those Victorian cases, it's been policies for registered housing providers under the Housing Act, for example, it's been relevant. So the second step, as I said, two-step test. I appreciate these are going to be not always straightforward to apply. So we've got to think about whether the functions are a public nature. And then the second step is it being performed for the state? And as I said, this functions of this idea of funding can be relevant to both. It's not determinative, but can be relevant to both if the entity is being publicly funded. But that's not the only way to demonstrate this. And there could be an agreement between the entity and the government to provide the service. There could be some delegation from the government to the entity to do that function. The entity might be required to apply government policies or regulations, or the government might have some other control over the way the entity performs the functions. They're all going to suggest that they're doing those functions for the state. So it doesn't always have to be your standard, 5-year agreement with government with regular funding. It can take the form of other criteria that demonstrate you're performing those functions for the state. So we have some well-known examples. I said public housing, social housing has been well established in Victoria. Another example often given, it's in the explanatory material for the Human Rights Act, is a private company funded to run a prison by the state. And then also out of Victoria, we have an example of a corporation which managed one of 5 sport and recreational centres on behalf of a local council. So there the council was doing some of them, a private entity was doing the others. And so that was, that demonstrated it was a function of a public nature. And often those will be the simplest. I can appreciate it's even trying to weigh all those factors I've given up. There's going to be circumstances when there's even more complexity where an entity has funding sources from various avenues. They're performing private functions. They might be funded by the Commonwealth to do certain things, and they've got these functions for the state government. As I said, the obligations only arise when you're performing those functions for the Queensland state. So that is, I appreciate, going to pose some complexity, and Chris might reflect on that too. But there is one way to solve that dilemma. Sorry, Stacey, that's the next slide.
I'm sorry. I
punchline.
I was hanging out for the dilemma.
So the punchline is you can opt in. So in Queensland and the ACT, you do have the opportunity to opt in, and then you have that clarity that you are a public entity under the Act. And it's quite a simple process. You write to the Attorney General and you ask to opt in, and you can write and ask to opt out. I'm not sure if we've got someone from QA here today, but as far as I'm aware, they're the first and only entity so far in Queensland to opt in. There's been about 6 or 7 in the ACT, and maybe if someone's here from QAI, they could, I'd not put them on the spot, but they might want to give some reflections as to what that's meant. I was going to speak about a complaints process. I might just very shortly hand over to Chris in the interest of time. I was just going to say, once you become subject to these obligations, one thing that may flow from that is a person can make a complaint to us. And I was just going to note that there is ability in the Act, a requirement in the Act, that the public entity be given the chance to respond. And we hope there's some dialogue between the individual and the public entity before the complaint comes to us. And often we're hearing anecdotally that a lot of grievances get solved in that requirement, so that it never ends up becoming a complaint to us. If it does, these are the criteria Jenny will have to apply. And really on its face, we're just looking that the complaint demonstrates that there's been some sort of breach of those obligations Chris is going to speak to. And then generally we'll hold a conciliation conference between the individual and the entity, and just see if we can resolve the complaint. And often the sorts of things that may come from that process are an apology, a change to decision or action, a review of policies or procedures. And then a very minority of cases, we've only got 3 to date that are published, we can, at the Commission, put out a public report with recommendations to the entity about how they can ensure their action decisions are compatible with human rights. But that, as I said, out of many, many hundreds of complaints, there's only been 3 of those reports so far. I'll hand over to Chris. I think, Stacey, this material is going to go out to participants, but that's some toolkits that they can use.
Thanks very much, Sean, and especially for your ability to move through that quite quickly. Thank you. Some really good information there. And as Sean has mentioned, we will send this out in a post-event email. These resources that you see on your screen now, you'll receive hyperlinks to them, all in a neat email, including some resources that we have to add to that as well. So I'm going to move on to Chris. Chris has joined us. He's a lawyer from Clayton Utz who has some really relevant, applicable information about decision making under the Human Rights Act.
Thanks, Stacey, and thanks, Sean, for that. So my name is Chris. I work in the public sector group at Clayton Utz in Brisbane. So our practice has 2 main components to it. First, we do public law litigation. So that's kind of, if anyone has a legal background, that's doing things like judicial review and things. So where people try and challenge government decisions in the court, and increasingly, and we'll come to this, when people are challenging government decisions in the court, they are looking to tack on human rights arguments. And as we'll see under the Act, if a public entity, including functional public entities, don't make decisions by fulfilling the public entity obligations, those decisions can be unlawful, even if the original kind of lawsuit that you bring is not made out. So it's really important that public entities and functional public entities kind of pay attention to these public obligations, and they're the ones on screen in section 58, because if you don't do that, you run the risk of your decisions being challenged on unlawfulness grounds in the court. So, and the second major area we do at Clayton Utz in the public sector group is to provide public sector advice. So we do a lot of statutory interpretation and help government agencies, large corporations, and a lot of non-government organisations understand what their legal duties are under laws and regulations. So, so that's the team that I sit in Brisbane. So Sean's quite helpfully kind of given you a bit of an overview of what a public entity is, and I'm going to take it to the next step and say, well, why is it important that you work out whether you are or are not a public entity? And the answer to that question is found really in section 58 of the Human Rights Act. So this is the section which imposes 2 obligations on public entities. So remember, when I'm talking about public entity, I'm including functional public entities who fall into that definition as well. So all public entities in Queensland, when they're making decisions, have to comply with what we call the substantive obligation, which is the first one there, section 58(1). So you must act or make decisions in a way that are compatible with human rights, essentially. And then there's also the procedural obligation. Now, this is the one I'm going to spend most time on today, and mainly, oh, sorry, Stacey, go back to the previous slide. Yeah, thank you.
I'm too excited.
So the procedural obligation is the second of the 2 obligations that public entities must meet under the Act, and that is when you're making decisions, it's unlawful for you to fail to give proper consideration to a human right relevant to that decision. So we call that the procedural obligation, and essentially, in a nutshell, it means when you're making decisions, you have to make them compatibly with human rights, but you also must record your decision making. And again, if any of your decisions ever get challenged in court and you don't record your human rights decision making, there's a good amount of case law which says really that the decision can be unlawful for a deficit of recording, keeping good records about your human rights decision making. So it's really quite important. And just but before we go on to the next slide, Stacey, it's quite important to understand that under the Queensland Human Rights Act, there's no individual avenue to seek redress in the courts for a decision just because you think it violates human rights. There's a complicated kind of mechanism that was included in the Queensland Act, which basically means you have to have another lawsuit going in the courts in order for you to add human rights grounds on. Practically, that's generally a good thing for functional public entities because it's unlikely that people will directly challenge your decisions. But for government departments, this is where the Human Rights Act has become particularly important because people will often bring legal challenges to government decisions by way of judicial review, which is just a fancy way of saying you're challenging the legality of a decision. And then they add these, what we call the piggyback. They piggyback human rights grounds onto that lawsuit. So for functional public entities, because your decisions are, it's not impossible for people to challenge them legally, for the legal validity on them, but it is a little bit harder. But it's still, that's a good thing from a risk point of view for functional public entities. However, it still is really important because there is a chance that any of your decisions could end up in court. And this is a way of protecting yourself, but also it's a way of making sure your decisions are compatible with human rights. So we might go to the next slide, Stacey. We can bring that up. So we're focusing really on that procedural obligation here. This is the decision. Basically, when you're making decisions, you have to make decisions. You have to accord with that procedural obligation, which just means you've got to give human rights proper consideration. Now, there are a few kind of court cases which have helped us work out what proper consideration really means. And one of the first points which has emerged from the case law in both Victoria and now in Queensland is that the judges don't expect you to do your proper consideration of human rights in a way that you might find in a legal judgment or in a legal textbook. It is really the case that you're meant to proceed in a very practical and common sense manner, and they're the types of language that the courts have used. So you don't have to have a law degree to comply with the public entity obligations. The courts do expect, particularly for functional public entities, that you proceed in a very practical and common sense manner. One of the things we do know, though, from the Queensland case law is that you must identify all of the human rights that may be affected by your decision. So Sean had a slide right at the beginning of all of the, hopefully you've all kind of seen the rights which are contained in the Queensland Human Rights Act. There's a link at the bottom of this slide you can see to the Queensland Human Rights Commission resources. They've got some really good resources that show all of the rights that are covered in the Queensland Human Rights: the right to education, the right for property not to be taken arbitrarily, the right to health services and things. So all of those rights there. So when you're making decisions, and a good example of this is if you are a housing service provider, for example, who's funded by the state, and you are involved in placing or managing tenants in Queensland public housing, you're almost certainly going to be a functional public entity. So if you are making decisions that revolve around someone's tenancy, that is going to be a decision. And when you make those decisions, in order to fulfill this procedural obligation, you're going to need to identify all of the human rights which may, and that's the interesting word in the Queensland legislation, that may be impacted by the decision. Now, the Queensland, Owen Darcy, anyone who's got a legal interest, is probably the best case we've had in Queensland. It was a Supreme Court decision which dealt with corrective services making a decision about whether a prisoner should be in isolation or not. And in that case, the decision maker failed to identify all of the rights that may have been impacted. They identified some, but they didn't identify all of the prisoner's rights which may be impacted. And because they didn't actually identify all of them which may be impacted, then the case, the decision was rendered unlawful on human rights grounds. So it is really important when you are making decisions, because you have the obligation to identify all the rights which may be engaged. You should have a copy of those rights, somewhere quite handy, and make sure that you write down all of the ones which may be. It's not enough to just do some. We do know you actually have to do all of them. That's one of the really kind of key things that have come out of the cases. In order to fulfill that public entity of the procedural obligation to give proper consideration, you need to turn your mind to the impact that the decision is going to have on human rights. You, as part of that, you've got to consider countervailing interests and obligations. So that's, again, just things that have come from the case law. And then the last stop point that's up there is you must consider compatibility with human rights. And that is essentially, there's a little bit of crossover between the two obligations under the Human Rights Act. If you consider compatibility of the decision in a proper way, then you will essentially meet that substantive obligation as well, which is the other obligation you've got to do, which is to act, when you make decisions, you have to act compatibly with human rights. So those, as I said, from a practice point of view, we've done quite a lot of human rights work in practice, and including for non-government organisations. And the reason I'm focusing on that procedural obligation, the obligation to show you've given proper consideration, is we often get clients who are responding to complaints in the Human Rights Commission, or government departments who are trying to defend decisions in the courts, and they say we considered human rights and we gave proper consideration, but when it comes down to the crunch, they don't have any evidence of it. So I guess that's my key point for you today, is if you think you're a functional public entity, and I think, it's hard to know, but I would just safely assume most people, Stacey, who are QCOS members, when they're at some stage, at some portion of their work, will be a functional public entity. If you're not recording your human rights consideration, you are not meeting your procedural obligation. And that's my kind of key takeaway, is the courts are saying you don't need to be sophisticated like a legal textbook when you do your proper consideration, but you do need to identify all the rights which may be impacted by your decision. If you don't do that, you're not meeting your procedural obligation. You've got to turn your mind to the impact the decision is going to have on human rights. So you have to, that just means you've got to evidence, and that can be in meeting notes, that can be in reports, it can be in briefings, but you must have evidence that you've turned your mind to the impact the decision will have on human rights. And you really, and this flows into that other obligation, you must consider compatibility with human rights. And considering compatibility with human rights in a nutshell, I heard the Queensland Human Rights Commissioner say this at a talk recently, which was quite good. I wrote it down somewhere if I can just find it. But it basically means if you're going to limit the rights, you are able to limit human rights under the Queensland Human Rights Act, but you have to justify them, and you have to do it essentially in a way that is the least rights limiting approach. So that really falls under that last dot point about, how do you consider compatibility of your decision making with human rights? And there's a whole nother kind of, probably a whole nother webinar on how you do that, but that's set out in section 13 of the Act, essentially. So if you want to see how you do a proportionality analysis, which is how you fulfill the requirement to consider whether your decision will limit human rights in a justifiable way, you look to section 13. But the essence of it is, if you follow those, these things that are up on the screen here, you keep detailed notes of what your consideration is, then you're going to meet that procedural requirement, the requirement to give proper consideration. So so that and these slides, as Stacey said, will go out to everyone. But that link that is on you can see the green link on this slide, will actually take you through to the Human Rights Commission's website, and they've got actually a dedicated resource for how to fulfil this procedural obligation. It's very easy to use and great. So I'm giving Sean and the Commission a bit of a plug here, but we often refer NGOs particularly to them because they're very user friendly and they're really ideal for NGOs. So
yeah, there's some fantastic stuff there.
Yeah. So I think that's it. So really, as I said, Yeah, we have found that a lot of NGOs, and I assume a lot of QCOS members, are really good at making decisions which are compatible with human rights, because you talk the language of human rights. You're generally very well aware of what the rights are, because they are drawn from the ICCPR and kind of well-known instruments. There are a few Queensland tweaks in there, so if you haven't had a look at what rights are protected in Queensland, I would encourage you to do that, because there are a few kind of ones that don't come from those well-established documents. But NGOs in general, we have found that they're very good at making decisions which are compatible with human rights, because it's part of the language that you'll speak in your work. But where we have seen in practice a lot of people fall down is they're just not recording their considerations properly. And if you're not recording it, as I said, you're not meeting your procedural obligation, that obligation to give proper consideration. And although the chance of an NGO decision being taken to court and challenged, and then people bring human rights concerns in the court case are lower than a government department, it is still a risk. And certainly we have seen, government decisions, big government decisions in Victoria particularly, have fallen over because the government departments have just not recorded. They cannot demonstrate that they've thought about human rights and how they'll be impacted, and that renders their whole decision unlawful. So there are serious consequences if you don't, accord to the procedural obligation, particularly.
That's really, that was really useful information, Chris, and it just really was making me think about, we did some work in case note writing last week, supporting the sector to understand the purpose and some of the principles around good case note writing, and some of the things you were just speaking about then really reminded me of how thorough we need to, it doesn't need to be complicated, but it does need to be thorough.
No. And I don't want to spook the horses or anything either, because, the human rights consideration, fulfilling the obligations, it's not meant to be an unobtainable task. It is it is the type of task which, people, everyone is able to do, and it doesn't have to be overly complicated. It just has to be done. And
that's right.
Yeah. And there is a little bit of a question over, I guess, we are often asked, like, what decisions do the public entity obligations apply to? Because, if you take a very broad view of decision or an act, government departments and functional public entities would undertake thousands of acts every day, like sending an email, making a phone call, choosing, there's lots of decisions and acts. But the nexus really is, if your decision may affect human rights in a real way, then you've got to give, proper consideration. You have to make decisions that are compatible with human rights.
Yeah, that's right. And so that support that we give teams and our colleagues to be able to make those decisions, and often we're having to make decisions quickly. That's the other tricky thing about I think giving proper consideration and being able to show how you followed that procedure internally is that we know that often services don't have the luxury of sitting back and considering something for a few weeks before they put it into place. We're often working in a frontline position in a crisis kind of environment.
Yeah. And that's, look, that'll bring me to my last point I'll say is, I guess the courts have, in general, they've been essentially said, the level of consideration you have to give is commensurate to the occasion. So, it really does, like, if a decision is going to have a huge impact on people's human rights and lots of people, the kind of like waxes and wanes. You've got to, the level of consideration will be more than a decision which may only just tangentially or may have a small chance of affecting someone. So, there's kind of like an inbuilt sliding scale into it as well. When your decision is going to have a huge impact on someone or have a big impact on a lot of people, you've got to spend a little bit more time doing it. So, or being a little bit more detailed.
Great advice. Thank you, Chris. And to you too, Sean. Now, despite our delayed start, we do have a couple of minutes left. I'm wondering if anyone does have a question or a comment to make before we close the session. You might have answered everything for them. Look, as I mentioned, we will be sending out a post-event email with all of the resources that were mentioned today. At the end slide I had there mentioned a few of the resources we have on Community Door. QCOS is engaged in a couple of projects now that have really assisted particular parts of the sector, particularly around housing and homelessness services, to apply the Human Rights Act to their work. And so there's a fairly extensive library of resources there on Community Door that we'll point you towards in the post-event email. And of course, if you have any suggestions about things that you would like to see through this series through the year, we'd be really happy to hear from you. If there are particular gaps that you found in the resources, we would be thrilled to jump into those gaps and put something together that would be useful to you. So please let us know. And if you are keen to continue having conversations, to be engaging in webinars like this one today, but also to be part of some peer conversations later this year, there will be a subscription link in the email that you receive where you can sign up to hearing all of our human rights content, which we are planning an exciting series of lunchbox sessions in the second half of the year where you will be able to discuss as a group of peers, colleagues in the community service sector, about different aspects of applying the Human Rights Act to your work. And we hope that will be a really useful and collegial space for you to discuss these matters. All right, there's anything anyone would like to say? Thanks, Anne, that's very kind. Before we go, Maria is going to trigger a poll to come up on the screen where here it is right now, where you can let us know what you think so that we can refine the session for next time. I'd like to thank Chris and Sean again for your time and for the teams behind you that support you, and for your generous sharing of your knowledge today. Really appreciate it. And I'm sure we will be discussing these things in the future. So thanks very much.
Thanks, Stacey. Thanks everyone for joining.
Thanks, Chris. Thanks, Stacey.
Thanks, Sean.